मुकेश भाई, मुकेश भाई, કાલરો સાહેબને અનમ્યુટ કરી જુઓ ને ત્યાંથી. એ ડાયરેક્ટ અનમ્યુટ નથી થતું.
ઓકે સર.
હા. Now you are unmute.
Yes, I'm unmuted.
Yeah.
I don't know since the last 10 minutes I'm trying to unmute and it's telling me the host is not allowing you.
Okay. Sir, I think you have two devices on.
Sorry?
Now it's one. You are having the two devices on. That's why.
It was echo, right?
Yeah. Now it's fine. I think so.
Good morning, Carlos sir.
Good morning.
Am I audible, sir?
Yes.
Okay. Thank you.
કાર્લો સાહેબના જે બે ડિવાઇસ ચાલુ છે.
Hello, am I audible?
No, I have single.
Yes, sir. Sabaria sir, shall we start the session?
Yeah, you can. Should.
Okay, sir. Thank you.
Yeah.
A very good morning to all the distinguished guests, invited speakers, delegates, and students present in this virtual event on this wonderful day. I, Esha Balsara,
and I, Richa Bhojla,
welcome you all to the DST-GUJCOST sponsored 2-day national workshop on intellectual property rights and patenting, organized by Tolani Commerce College, Adipur, Kutch, Gujarat, in collaboration with LM College of Pharmacy, Ahmedabad.
एक लाइट बंद कर दो ना, आ बाजू में स्विच.
Before we commence for actual proceeding of webinar, we must express a deep gratitude to Almighty God by offering prayer. I would like to invite Isha to recite a prayer for us.
या कुंदेन्दु तुषार हार धवला या शुभ्रवस्त्रावृता या वीणा वरदण्डमण्डितकरा या श्वेतपद्मासना या ब्रह्माच्युत शङ्करा प्रभृतिभिर्देवैः सदा वन्दिता सा मां पातु सरस्वती भगवती निःशेषजापः. अस्तु.
Thank you, Isha.
With great pleasure, I would like to invite Dr. Manish Pandya sir, Principal, Tolani Commerce College, to address our guests and audience. Sir, please join us on this virtual stage. Sir is a regular full-time principal at Tolani Commerce College, Adipur, Kutch. He has worked with Bhavan's Arts, Science and Commerce College, Thakur, Gujarat. Sir is a member at NAAC since 2011. Sir is a recognized PG teacher, MPhil guide, and PhD guide. Sir completed a UGC minor research project in 2008 to 2010. Sir is editor-in-chief at TCC Samiksha, which is an international multidisciplinary biannual journal. In all, 59 conferences, seminars, and workshops he has attended. He has attended a 5 UGC-sponsored orientation and refreshers program organized by MS University of Baroda. Sir is an NSS program officer. He is a member of many international, national, and local associations. Sir has published many papers in journal and wrote various articles and chapters which are published in reputed books. Sir has completed research projects under the title of Use of Information and Communication Technologies in the Teaching of English in Rural Areas. We are pleased to have you here, sir.
Thank you. I think I am audible. Am I?
Yeah. Good.
Okay. Thank you. Respected dignitaries on the platform of webinar screen, our mentors, speakers of the workshop, principals and the staff, members of LM College of Pharmacy, all the organizers from both the colleges, technical teams, and dear participants. It gives me a pleasure to welcome all of you and speak to the opening ceremony this morning to the National Workshop on Intellectual Property Rights and Patenting, jointly organized by Tolani Commerce College, Adipur, and LM College of Pharmacy, Ahmedabad. As we know, this century is referred to as the century of technology, knowledge, and in fact, the rhyme of intellect. The country's ability to translate knowledge into innovation, to gain wealth, and determine its future. Thus, the innovation is supposed to be the key to create knowledge into wealth. Therefore, issues of generation, evaluation, protection, and exploitation of intellectual property would become critically important all over the world. Through this workshop, I suppose emphasis has been given on the IPR's impact in creating a strong backbone of the country. This workshop will provide us not only essential knowledge, but also a great opportunity to share experiences, both technical and regulatory issues. I would like to take this opportunity to welcome the organizers and in particular our honorable speakers. All of them have been working with us since the beginning of the planning stage, and they are still here today for all of us. Since the beginning of the planning stage, all have worked hard, and the result is today's workshop. So on behalf of Tolani Commerce College and on behalf of LM College of Pharmacy, Ahmedabad, I welcome all the dignitaries and I welcome even all the participants who have joined, without whom this workshop would have not been possible. So once again, I welcome all of you to this workshop and hope the best out of this 2 days talk. Thank you. Thank you very much.
Now I would like to invite Dr. Mahesh Chabaria sir, Principal of LM College of Pharmacy, to brief us about the workshop. Over to you, sir.
Thank you, Richa. Very good morning to one and all. Respected Professor Kalro sir, Academic Advisor of the Education Society and Chief Guest of the today's function. Respected Sri Padmin Bhai, IPR expert and distinguished alumni of LM College of Pharmacy. Dr. Manish Bhai Pandya, Principal, Tolani Commerce College. Coordinator of this workshop, Dr. Mukesh Bhai Kher and Dr. Dipen Bhai Sureja, all respected faculty members and dear participants. On behalf of LM College of Pharmacy and Tolani Commerce College, I heartily welcome you all to this today's GUJCOST sponsored today's national workshop on IPR and intellectual property right and patenting. The word IPR is, I suppose, is not new to all of us, but it's very important and essential whenever we are talking about innovation and invention. And when I am talking about the innovation and invention, we always think that innovation and invention can be done by only the technical person. It's not correct. Each and every individual on this globe is unique. He or she has a unique intellect, and he and she has an intellect, a unique brain. So anyone can produce innovation or invention, and when we are doing so, obviously first step is to get that intellectual protected. Whatever new thing you do, that has to be protected. Because whenever we are doing innovation and invention, we have many things in mind. I may get the financial gain through this innovation or invention, or I may serve to the society without a financial gain also. But whenever whatever we are doing in terms of this, it has to be protected. Otherwise, it will be copied by anyone and your right on that goes away. And there, this is very important. So, to get the intellectual property right is not a straightaway process. Just you put an application, you get the intellectual, you get the patent. It has many steps to go. It has the formal process to undergo. Now, keeping that things in mind, we thought, why not to organize a kind of a workshop where we can invite a galaxy of speakers, eminent speakers. They can guide all of us. We may be knowing the basics, but many things are updating, many things that come new in this. So this updated knowledge we gain through this kind of workshop or the webinars. And keeping this thing in mind, we have organized this 2 days workshop, and we have invited a very renowned eminent speakers for this workshop. They will be guiding us, or they will enhance our knowledge specifically for the IPR and patenting. And I'm sure for all the participants, this workshop will become a knowledge gaining specifically in the field of IPR and patenting, which is very important and essential nowadays. So again, I welcome you all. I welcome all the eminent speakers also. And thanks for accepting our invitation on first call and being present over here to enhance our knowledge. Thank you all.
Thank you so much, sir. Now, I would like to have the opportunity to introduce our guest of honor, Dr. Padmin Bhuj, sir. Mr. Padmin Bhuj, sir, is a senior IPR domain expert and also project and management advisor. He holds about 30 years combined experience of intellectual property rights, corporate industry, and entrepreneurship or startups. In the IPR, he is recognized as one of the national experts with specialization in strategic implications of IPR in pharma and healthcare domain. Mr. Booth, sir, as the Managing Director of GITCO, established a patent cell at GITCO Ahmedabad. GITCO patent cell filed more than 65 patents for startups, MSMEs, research institutes, individual researchers, and academic under his domain. As the Chief Advisor at the Gujarat Technological University, he is credited with creating very active IPR culture in more than 60-degree engineering and 40-degree pharmacy college in Gujarat state. Sir has been awarded the prestigious IP Samaritan of the Year 2018 award by IPPO in August 2018 and the GTU Pedagogical Award for contribution in IPR and innovation domain by Gujarat Technological University in year 2013. Mr. Padmin Booth, sir, is a Director Troika Pharmaceuticals Private Limited, Chairman USIIC Counseling on Life Science and Intellectual Property Rights, Chairman, Board of Advisor, Acuprec Research Labs member, Apex Committee on IPR, Government of Gujarat member, Advisor Committee on IPR, Gujarat Technological University, and member of many more organizations. We are honored to have you, sir. Now I shall request Dr. Padmin Booth, sir, to deliver an address to our audience. Thank you.
Thank you. Thank you, Richa, for the kind introduction. And good morning, all. Respected Professor Dr. Carlo, Dr. Sabaria, sir, Dr. Manish ji, the entire team of LM College of Pharmacy and Tolani Commerce Institute, and my fellow faculty members, fellow speakers, and the participants. I can see the participant number, which is crossing almost 160. Well, the number is not important, but the fact remains that this kind of workshop has attracted such a large number. That gives something good for the future of intellectual property right, with which we all are wedded. First and foremost, I would like to thank both the institutions for inviting me to be part of this important national workshop. As Dr. Chabaria sir said, yes, for me, there is an added feeling of being proud. I am an alumna of LM College of Pharmacy. I did my graduation in pharmacy long back in this college, and I can never forget those years. And it has taught me so much thing. And I must acknowledge the contribution of the college. And that is why I always love to be part of the initiatives of the college, which are there being taken very many. So thank you once again for that. This workshop, two-day workshop, has been designed in a very fine manner. I went to it. I am a part of so many workshops. I am, as I said, national, international level, I am involved in intellectual property right. I call that intellectual property right is my profession as well as passion. The passion is very important. Intellectual property right, we have been talking about since some time now. Idea is to build a culture. What is culture? It should be from part of our day-to-day, our business models, our activity, whether academic or industry. Unless and until IPR becomes a culture, we will be moving around circles only. Fortunately, the announcement of national IPR policy about 4 years back has really made a huge difference. I was part of the subgroups of the formulation of national IPR policy. It is one policy which is very pragmatic, practical, and application oriented. It covers all the key aspects. One of the important part of the national IPR policy has been creating a pool of IPR knowledgeable people. We don't want everybody expert, but they should be knowledgeable about it. And who can be better than academic institutions to build this kind of pool of the people who know IPR? And that is why I'll always be part of any institutions we do it. Another thing Dr. Chabaria rightly said is that yes, there is an element of technicalities when somebody goes for patent, but that's all. Anyone can be an inventor, and anyone can be the holder of intellectual property right. You know, intellectual property right is the all pervasive. Not, yes, pharmaceutical remains one of the core area, but you pick up any field, whether it's an industry, is a service industry. Sports. Just now, Tokyo Olympic was completed. You know how much intellectual property right played a role, starting from the logo of Olympic to all the campaigns, trademarks, designs of the football, designs of the hockey stick. Everything is covered under intellectual property right. Whether copyright, design, patent, or whatever you call it. Sports is a big field which has emerged in last 5-7 years. Similarly, leisure and entertainment industry, film industry, for example, is one of the biggest user of intellectual property right. Whether it's a music, whether it's a script, whether it's a dialogue, whether it's a title. Now, all these areas, tourism is another big field where intellectual property rights emerge as a major factor. Now, all this thing doesn't require a technical person. Any person who wants to understand and practice intellectual property right can go into the field. So that is why I'm happy that two institutions, one pharmacy and other commerce and management institution, have joined hands together. I really encourage such kind of collaboration. I must compliment both the institutions that they have joined hands. That is going to set a precedent that IPR is not only a technical domain. Okay, IPR is a all pervasive thing, and I must compliment for that. Just like national IPR policy, just recently we completed 1 year of national education policy. Now this recently about 10 days back, I was invited to talk about after completion of the 1 year of national education policy. And there I also emphasize the same thing. It's a practical oriented education policy, very comprehensive policy, which has been brought out after 35 years. There also, if you care to read in detail, there is a specific mention of creativity, innovation, and importantly, intellectual property right. Okay. Third thing, patent and IPR are not only academic, they are not bookish thing, they are practical. They are oriented with the business and industry and society, whether it's a trademark, whether it's a design, whether it's a copyright or a patent. It has to be of some use in the business and society. And for example, you know, I have been to China a few times. Abhi to China jana nahi hai. Bahut ho gaya China jane ka. But China not only files lakhs of patents, but it is also ahead in several other initiatives. Like in China, if you got 10 patents, you can value those 10 patents, go to the bank, and bank will give you loan on that. Just like you mortgage your asset, machineries or building, you can mortgage your patent. Now, these things is part of our national IPR policy. Things are being done. It is taking this slowly, but it is going to come here. When patents valued at a certain cost, price, you can go to the bank. Now, who will do this valuation, my dear friend? It is a combination. There is one person who is a technological person. He can understand the patent value. Other person is a commerce person, a company secretary, a patent valuer. There is a 6-month course on patent valuation online. I am part of it. Most of them are commerce graduates. Most of them are management graduates. Most of them are company secretaries, or some of them are chartered accountants. So, emphasizing the point that IPR is, yes, base is technical, but it is much more than technical, commerce and legal. Okay, this is IPR, and that is why I'm happy that both the institutions joined together to organize this excellent workshop. It has an excellent coverage, fine faculty. मेरे को मत गिनना, बाकी सब अच्छे हैं. So they are fine faculty, and I wish all the best to this 2-day webinar, and I'm sure that this will lead to many more students, academicians, and researchers to get encouraged and go for intellectual property right. Not necessarily only technical invention. Yes, technical invention is fine, but you can do, no, there is, for example, I will just take 1 minute. There is a facet called geographical indication. Now, what is GI, geographical indication? It is part of the IPR. A product either being manufactured or being grown, natural product, in a particular region is given the tag of GI. Apna Gujarat nu che a Gir Kesar mango, for example. Okay, now it is a GI. There are so many GIs like this. Now, you know, my dear friend, this has emerged as a major international marketing tool in the world because it gives the originality and authenticity. 1 year back or 1.5 years back, our Gujarat's Patanna Patola was given GI and I was part of it. Patanna Patola now has become international name. All the foreign tourists who come, they come with a list of the GI in Gujarat. They go to Patan and it has given them a big rise in their market. So my dear friend, IPR is a very much part of our business industry and society. Last point, industry academic collaboration is the key for IPR. And I know that LM College of Pharmacy is doing very good work in this kind of collaboration, always inviting industry people to be part of the process. This has to continue. World over, this is happening and we should take up in the right manner. Thank you once again. And I wish all the very best to this 2 days webinar on IPR and patenting. Thank you.
Thank you so much, sir. Well, we deem it a great honor to have with us Dr. A.H. Kalro, sir, as today's chief guest. Let me take this opportunity to introduce you, sir. Dr. A.H. Kalro, sir, is a professor at Emeritus at Ahmedabad University and academic advisor to AES after serving as Provost Ahmedabad University. He is educationist with more than 45 years experience in academic institutions in India and abroad. Sir was a member of the Second Administrative Reforms Commission, Government of India. He has also worked as a director at IIM Kozhikode. Professor Kalro has obtained his BTech Honours degree in Electrical Engineering from IIT Kharagpur in 1963 and his MS and PhD in Industrial Engineering from the University of Minnesota, USA. He is a recipient of several scholastic and teaching excellence awards. His research publications are in the areas of inventory management, organization, behavior, irrigation, and water management, management of educational institution, and in institution building in reputed international and Indian journals. He has also co-authored 3 books and has extensive consulting experience with public and private sector organizations. He has traveled extensively to more than 30 countries and has taught in programs in Japan, Kenya, and Sri Lanka. He has served as a board of directors at several prestigious corporates like Bharat Petroleum Corporation Limited, Bharat Oman Refineries, Torrent Power SEC Limited, to name a few. He was associate editor of Obserts and founder editor in chief of Ames e-Journal. Dr. Kalro was presented the Lifetime Achievement Award by the Indian Society of Operations Management in December 2006 and awards from Ahmedabad Management Association Ahmedabad and the School of Planning and Architecture New Delhi for his contributions to management. With such an impressive CV, we are obliged to take it today, sir. Now, I shall request Dr. A.H. Kalro, sir, to deliver an address to our audience. Over to you, sir.
Thank you very much for the kind introduction. Dr. Padman Butch, Dr. Mahesh Chabria, Dr. Manish Pandya, other dignitaries present today in this inaugural function, participants of the workshop, the 2-day workshop that is being organized, and also our eminent speakers who are going to be talking to us on this issue during the next 2 days. It is indeed a great pleasure to be a part of this inaugural function, and doubly so because of my association with both the institutions who are co-organizers of this function or this workshop. I happen to be a trustee of the Gandhidham Collegiate Board, which is the founder of the Tolani Commerce College and runs this college. And as was mentioned, I am associated with the Ahmedabad Educational Society in various capacities since the year 2004, and now presently as the academic advisor for the granted aid colleges, of which the LM College of Pharmacy is one of the important members. So indeed, for me, it is a great pleasure to be part of this function. And I thank the organizers and Dr. Chabria in particular for asking me to say a few words this morning. Actually, Dr. Padmin Butch has laid out very, very clearly and lucidly the issues and concerns that we need to be aware of, and has drawn a roadmap for us to be able to follow both in academia and in industry to promote intellectual property rights and patents. So I will not actually repeat or make reference to those kinds of issues again, but instead I would like to raise one or two other concerns about this whole issue of intellectual property rights. Notwithstanding the fact, at the very outset, I will state that it is extremely important, it is crucial indeed for individuals, institutions, and countries to pursue this whole concept, this whole theme in years to come. Now, IPR, to my mind, has essentially been a route to monetize knowledge and the applications of knowledge or the outcomes of knowledge. So be they innovations, be they inventions, or anything else which has arisen out of existing or newly generated knowledge. And in addition to monetizing the knowledge, one is also provided exclusive ownership of the ability or opportunity to commercialize the outputs of that knowledge, be it products or anything else. And in this context, we must recall that some countries which have had a long record in the last century of research, invention, innovation, and so on, to actually be able to amass what I would like to call as tremendous wealth arising out of intellectual property rights. And sometimes, of course, to the disadvantage of those who cannot afford to pay for the products and services which are derived from these rights. So there are just two, three issues that I want to draw your attention to for discussion purposes only. And I repeat again, this is not to question the desirability and suitability of intellectual property rights, but to be also concerned about what we need to do in the road ahead as a world community. The first thing that I want to draw your attention to is that before the intellectual property rights were legally recognized and agreed upon by many countries, for example, China was mentioned. They did not subscribe to IPR for years and chose to violate the IPR that was available to other countries. We in India also said that we recognize only certain kinds of IPR and so on. But that apart, what about all this knowledge that has been generated centuries ago, some of it even thousands of years ago, which today has been the basis for certain kinds of inventions and innovations on which the rights are being enjoyed by people and countries now, but absolutely no credit is given to those individuals, their successors, their countries, on what they contributed. I think this is a very important issue. And I think we have to be able to recognize the fact that not everything is patentable. not everything should be patented, and not everything should IPR be awarded, even though it falls into a category of invention or innovation. And here also, by the way, there are many examples. There are organizations and countries which have tried to give themselves the intellectual property rights and patent items like haldi and basmati rice. These are all famous examples that you're aware of, which are also forcing me to raise this issue with you, where credit lies to institutions, countries from hundreds of years ago. What should be the basis of giving them some share in this asset that is now created and which is being monetized by those in the present occasion? That is point number one that I want to raise with you for deliberation and some basically understanding on what we can do as we move forward in this century. The second thing that I want to draw your attention to is the fact that we are now increasingly conscious in the world because of the pandemic about the need and importance of countries to cooperate, collaborate, partner each other to resolve issues and solve problems that are threatening the entire world, the global community. Already some beginnings are being made in this context. For example, India was one of the prime movers with some other countries seeking exemptions from IPR issues in the context of vaccines that were being produced for the corona pandemic. Similarly, these issues have been raised in the context of AIDS and so on. And very interestingly, I want to draw your attention to this. Very interestingly, the highest courts, both in the United States and India, have come out with unequivocal, clear judgments that when countries are doing this kind of service to others, other nations and people, it cannot and should not be deemed as a violation of the intellectual property rights of those who were actually in possession of them. That's the second point I want to make. So there has to be not a tight intellectual property right which is granted to nations or organizations or individuals for certain kinds of things when need arises. So what we need to work on is caveats. We need to work on caveats which will enable meaningful waivers for these rights with the consent of those concerned. That is the second point that I want to raise with you. And the third point that I want to raise with you is that invariably, with the disparities that exist between communities in the world and the state of their own intellectual capacity and knowledge as of now, service to humanity may demand that exclusive rights may not be given to an organization, an individual, or a country for certain kinds of outcomes and products of knowledge which has secured or received an intellectual property right. What should they be? I don't think there are clear answers to any of these issues, but these are issues we must address. These are issues which we must address with courage. And these are issues which we will have to face with understanding and above all, with the interest and well-being of the global community. Having said this, let me just say that it is indeed a pleasure for me to have been a part of this inaugural function. And I thank both Dr. Chabria and Dr. Pandya for giving this opportunity to share some thoughts. And I am certain that with the kind of capability that is being brought in to advise us, educate us, inform us, show us the way ahead, we will certainly be able to better understand and take the necessary recourse to getting the intellectual property rights that we deserve as we move ahead in our efforts. Thank you very much indeed. Hearty congratulations for organizing this workshop, and all the best in terms of the 2 days that lie ahead for all in this whole lot of deliberations that are going to take place. We could not have asked for better people to come and talk to us and educate us. So congratulations, Dr. Chabria, and also Dr. Pandya, who together with the help of, I think, Dr. Buj, have really drawn up this entire program. Thank you very much, and bless you all.
Thank you so much, sir, for the fabulous and best. I would now request Dr. Mukesh here, sir, to give a thanks. Over to you, sir.
Very good morning to all the dignitaries, respected Dr. Kalro sir, Dr. Padmin Buj sir, Dr. Mahesh Chabaria sir, Dr. Manish Pandya sir, all head of the department, faculty members, students, and all the delegates from the different corner of Gujarat as well across the India. It gives me immense pleasure to propose the vote of thanks at the end of this inaugural program. First of all, I would like to express my sincere gratitude to our chief guest, Dr. A.H. Kalro sir, Academic Advisor, Ahmedabad Education Society, Ahmedabad, for his kind acceptance to grace the occasion as the chief guest for this inaugural world. Sir, your association with us always inspires us, and I am sure with your blessings, we will gain further strength. I would like to express my deep thanks to our guest of honor, Dr. Padmin Buj sir, IPR domain expert, senior visiting faculty, EDII Ahmedabad, for setting the tone of the event through their insightful inaugural address. We are grateful to all the eminent speakers, namely Dr. Padmin Buj, Dr. Rajesh Kumar Acharya, Mr. Nagesh Nanda, Dr. H. Purushottam, Mr. Philip Abraham, Dr. Praful Baradia, and Mr. Amit Patel for accepting our invitation for this e-workshop. We are very much thankful to Dr. Mahesh Chabaria sir, Principal LN College of Pharmacy, and Dr. Manish Pandya sir, Principal Tolani Commerce College, Adipur, for all the inspiration and support they have extended in making this program a successful one. Sir, you both deserve a big hand of applause for the amount of meticulous planning and overall supervision. I must not forget to mention about the help and logistic support imparted by our organizing committee member, namely Dr. Anuradha Gajjar, Dr. Kamal Kharecha, Dr. Gaurang Shah, and Dr. A.V. Bharti. I am very much thankful to my colleague, Dr. Jagdish Rayani, Dr. Deepen Sureja, and Kumar Jai Sakya for his active involvement in planning and executing each and every activity to make this workshop a grand success. I also thank all head of the department from both the institute, entire organizing team, and all the teaching staff members who are continuously working since many days to execute various activity of the workshop. I also wish to thank all the delegates who have made this event a true reality by participating in this workshop. I also put my gratitude and sincere thanks to DST-GUJCOST for financial assistance and sponsoring this event. I also thank our students, Isa and Richa, for such a nice anchoring. Thank you all once again, and we look forward to an extremely productive session. Thank you.
Thank you so much, sir. Before we start the session, I would like to inform participants that a question answer session has been arranged in the end. So if anyone want to ask anything, please write in the chat box. It will be answered in the question after the end of the session. I request all the participants to mute their mic to avoid the disturbance during the sessions. 80% attendance is mandatory to be eligible for the certificate. Feedback link will be shared at any time in between sessions in chat box as well as in Telegram group. It will remain open for a short period of time after sharing. So please be attentive. Thank you.
Thank you so much, Rita. Now, without further delay, we will proceed towards today's session. I would like to invite our first speaker, Dr. Padmin Butt sir, to give a talk on IPR and overview. Dr. Padmin Butt sir is a senior IPR domain expert and also project and management advisor. He holds about 30 years
Hello,
combined.
I request you not to repeat the introduction.
Okay, sir. Okay.
Thank you so much. It has just been introduced about 10-15 days back. Thank you so much.
Thank you.
Thank you. Sorry to interrupt, but that's what it is not necessary. That is why. I think I will let me try to share my presentation. And if I'm not able to share the presentation, I will requested LMCP to do the same. But let me first try on my own. Okay. Okay, is it visible?
Yes, sir. It is
Yes, sir.
visible.
Okay, fine. Okay, thank you once again. And without further delay, let's start talking because it's an excellent lineup of speakers after me also. In fact, I would say they are much better than me. So पहले बोलने का फायदा यही है कि जो बोल रहा है बोल दिया बाद में कंपैरिजन होगा चला जाएगा. But anyway, thank you once again. It's very important to set the ball rolling, although set the tone, which I have tried to do briefly in my inaugural speech. I am going to give you an overview of intellectual property right. What IPR is, what are the main components, and briefly discussing each of the components. And towards the end, I would like to also touch upon the importance of intellectual property right for academics, industry, and society in general. Professor Dr. Carlos sir has raised some very pertinent issues. In fact, I'm happy that one has to raise certain issues. It is not always that everything is rosy. Yes, IPR is the need for everyone. There is no doubt about it that he also mentioned. At the same time, he raised a couple of issues, or we can say a couple of aspects. I will also briefly touch upon that as a part of my discussion just now. I will try to enter that part also. Okay. Look, this is a slide which I always have, whether I am talking about IPR or whether I am talking about management, whether I am talking about project management or international business, which are not my domain. It is related to intellectual property right only. What it says, that some of the things which are reproduced from other sources, it could be copyrighted also. Look, whenever we prepare some kind of work, whether we prepare a research report, whether we write an article, whether we write a PhD, doctoral thesis, we also have a lot of things we take from outside. In fact, that is necessary. Nothing wrong with that. But do we acknowledge that? Do we acknowledge this? Do we take permission from the original author? It is so much necessary to do that. Because, my dear friend, it is not only moral and ethical requirement, it is also legal requirement. At the end of the day, intellectual property right is based on a sound, comprehensive legal framework. Okay, so this is required to be done. This is to be kept in mind, and that is part of the awareness. It is so much required, and people don't do it, and they end up in litigations. Okay, so it's a competitive world. We know everybody is racing. To be competitive, everybody is racing, running. But do everyone race in the right manner? As this says, these four gentlemen behind, they are racing because somebody ahead is racing. Symbolically, instead of their mind, a clock has been fed. They run without thinking much, maybe. Now, this kind of racing will not lead you or lead anybody to a competitive age. A different approach is required, and that is innovation. My dear friend, innovation is the key to be competitive, as has been well mentioned by the earlier speakers. And innovation doesn't have to be rocket science. Small but useful, meaningful innovations are the key. Okay, this innovation could be anything. This is an innovation. Of course, this is some lighter when I'm showing, but there is a message. इतना बड़ा कैप्सूल है. What does it say? Each capsule contains your medication, also a treatment for each of the side effects. Now, this is not innovation we are talking about. Okay. Hello, somebody is annotating, I believe. I request, you must be seeing a lot of lines over here. Can you see the lines? Hello? I request nobody should annotate. Yeah, thank you so much. Okay. So this is the what we call workable innovation. An innovation which is viable business-wise, an innovation which is desirable. There should be need. People should feel, yeah, ये हमारे लिए है innovation. ये काम का innovation है, useful है, and innovation which is feasible, जिसका हम actually practically implementation कर सके. This is called workable innovation. And again, I am emphasizing, not necessarily very big innovation. And when someone comes out with such kind of workable innovation, it creates what we call intellectual property. So that is the basic concept, my dear friend, of intellectual property. हम जो बोलते हैं हिंदी में उसका बहुत बड़ा अच्छा शब्द है बौद्धिक संपदा. Property. A property, we normally are used to have property like building, furniture, car. These are all tangible properties. Intellectual property is an intangible property which is taking the world ahead, my dear friend. So that is why it is said intellectual property is a creation of mind. Whether it's an industrial invention, which can be protected under patent, whether it's a literary work or artistic work or research work, papers, which can be protected under copyright, whether there are symbols, logos, brands, which can be protected under trademark, or an outer shape of a product like furniture, it can be protected under design. So essentially, intellectual property is a creation of mind, and intellectual property right gives the right of ownership. अगर किसी ने इनोवेशन किया, उसका ट्रेडमार्क लिया, उसका पेटेंट लिया, तो वो इंडिविजुअल या तो इंस्टीट्यूशन या तो कंपनी, they become owner of it for the given period of time, for 10 years or 15 years or 20 years. Now here, Dr. Professor Carlo raised a very relevant aspect. 20 साल के लिए पेटेंट मिलता है, for example, whether it can create monopoly, whether it will become a situation where people are deprived of that useful product or creation because somebody has a patent and nobody else can do anything about it. Yes, this were the fear and raised threat, but over a period of time, World Trade Organization under the TRIPS has come out with several clauses where such kind of monopoly, if results, can be taken care of. Okay, so that is now taken care of. That is no more a fear that somebody will sit on it and other people will not get it. So these are the creations of the mind, my dear friend. And that is why it is said ownership of intangible property. which is an intellectual property. Tangible property, we can see, we can touch, we can feel. Intangible, we know it is there, but we cannot see it. So it has to be converted into intellectual property. And world over, it is the intangible assets which are taking the business and society ahead. This is a symbolic figure where it is shown that US company, the companies in the United States, over a period of time, their intangible assets are increasing, and which is taking them and the country forward. If you see the balance sheet of such kind of companies, you don't see very much investment in building and machineries, but there are hundreds of patents with them, hundreds of trademark and designs with them, which is a intangible asset, which is intellectual property, which is taking them ahead. Take the example of countries like South Korea and Israel. I have visited both of them, all the three of them, of course, US also. How South Korea and Israel has gone ahead? By doing innovations of the kind their country requires. That is a creation of IP, which is an intangible asset. And my dear friend, you know, most of the initial work is being done as an academic and research institution. Then they convert into IPR and they go ahead. This is a big concept. Fortunately, हमारे वहाँ अभी उसका काफी बढ़ावा हो रहा है. We were lagging behind. Now we are catching up, and hopefully we'll be at par with many countries in next decade. So the IPR, that is the context I just talked about, it confers the right of ownership. If you do innovation, if a student, if a faculty, if an individual or a company does innovation, should not that person or a company or institution have ownership? Why? Because that motivates that person, that motivates that company, that motivates that institution. Yeah, now it is my own. I can hold on to it. I can make the best use of it. You can share it, but it is the owner of the patent or a trademark which decides with whom he or she will like to share, and that is ownership. वो उसके ऊपर बैठा नहीं लेने वाला है. It has to be utilized, and non-utilized intellectual property right has no meaning. So it has to be utilized, but the person who has invented it, who has done the basic creative work, should have the right to decide with whom to share and who is the right people to be shared. It's a big concept. It is a required concept. It encourages innovation and innovative process over a period of time. These are the main components through which intellectual property right or right of ownership is given. Patents, designs, trademarks, copyrights. These are the main four. There are others also. We're going to talk briefly about each of them. There are others also, as I just mentioned earlier, geographic indication. There is also plant variety protection. It is a very important provision in the intellectual property right law in India particularly. You know, the farmers who are the basic people who provide the agriculture outputs to our country. If somebody, a new company comes, they come out with a new kind of varieties of the seeds and plants. So farmers को धक्का लगेगा. तो ये जो act है, वो they protect the farmers. They don't allow anybody to take away rights of the farmers. Just like Professor Carlos mentioned of the haldi and basmati rice. There also India was able to fight and tell the world कि भी हल्दी जो हमारा प्रोडक्ट है हम भी पैटर्न नहीं ले रहे हैं, दूसरे किसी को पैटर्न नहीं मिलना चाहिए, and we won the case. So my dear friend, all these are based on legal framework. So IPR is a technical, commercial and legal all put together kind of. Okay, we'll talk mainly about patent, trademark, designs and copyright, more so on patent. This is the system of IPR or patent in our country. Indian patent system or Indian IPR system is directly under the Department of Industrial Policy and Promotion, what is called DIPP. That department in turn is under the Ministry of Commerce. Government of India. So in India, intellectual property rights and patents are totally under the jurisdiction of central government. State governments have no direct role in terms of policy formulation and implementation. They are the kind of channelizing agencies. And let me tell you, world over is the same situation. Most of the countries, the IPR framework is under the central government only. These are the various offices in India. As it can be seen, design wing is in Kolkata. The patent office is in the 4 metros, Kolkata, Delhi, Mumbai, and Chennai. Trademark offices, in addition to the 4 metros, it is also in Ahmedabad because Gujarat is considered to be one of the major entrepreneur and business state. So they have allocated one office of trademark in Ahmedabad also. The office for geographical indication is in Chennai. Whereas in Nagpur, there is a big database related to IPR and patent. These are all under Government of India, as I said. Copyright office is located in Delhi. Earlier, copyright was not under the same department. It was under the Department of Education. Now, after the national IPR policy, copyright also is a part of the Department of Industrial Policy and Promotion. This is just to give an idea what is the organization framework in India. At the world level, other than that World Trade Organization, WTO, there is a major organization called World Intellectual Property Organizations, WIPO, WIPO. It is a UN agency, United Nations agency, dedicated to the use of intellectual property as a means of stimulating innovation and creativity. WIPO is not a regulated agency. It doesn't enforce law. It facilitates the use of IPR. It's an excellent agency. It is based in Geneva, Switzerland. WIPO runs several online programs also. In general, WIPO is considered to be an organization which helps promoting awareness and use of intellectual property right in the world. More than 180 countries are members of WIPO, including our own country. Okay. Now let us talk briefly about this different kind of IPR component. Trademark. Everybody knows trademark. Maybe everybody doesn't know the importance of trademark. It is an identification symbol, no, a kind of logo, a kind of name. Let me show you. Now here is a source. It's a logo of LMCP, LM College of Pharmacy. Okay. Then there is a logo, various logos, as you can say here. There is a logo of ISI. There is a logo of egg mark. There is a logo of ICAR, which is Indian Council for Agricultural Research. There is a logo of Indian Institute of Technology. Now, somebody may ask the question, are they organizations trading? How can they be given trademark? No, it is an identification symbol. And that is why it is called service mark. As it can say middle. A TM is written when somebody applies for the trademark, but it is not given yet. It is in the process. So one can write TM. Once it is registered, trademark is been sanctioned, one can write R. You must have been observing many times what is sometimes people write TM, sometimes people write R. Now we know what is TM and what is R. SM is for the service institutions. Now each and every education institution, every government, most of the government departments have their own logo registered under service mark that gives them an specific identity. Of course, these are known world over, world famous global trademarks. They are so known, you feel like they are part of our life. Whether it's a Coca-Cola, whether it's a Nike, whether it's a Pepsi, whether Domino's Pizza, Samsung, all very well known trademark. They create an identity of the product and the company. Of course, these are known. State Bank of India, Facebook, which everybody loves and hates both. Mercedes-Benz on the left-hand bottom corner, and Apple computer logo at the right-hand bottom corner, and middle center, our lovable Amul girl. they are so well-known trademark that one doesn't have to write the name. By simply saying that, we know, okay, it is a logo and trademark of State Bank of India or Amul or Apple Computer. And that is, my dear friend, is the most important commercial part of trademark. It creates a huge value of a particular product or a brand or a company. Companies also have their own trademark, like Reliance Industry, Tata Industry. These all have a trademark. You know Tata logo, you know Reliance logo. It's a huge commercial value, my dear friend. I'll briefly talk about a couple of cases, because trademark is a domain where a lot of litigation take place. One has to be really aware what to be do. So Sunit Pharmaceuticals and Sun Pharmaceuticals. Now, Sunit Pharmaceuticals was started by Dr. Dalal sir, one of the early BPharms from LF College of Pharmacy, very respected person. He unfortunately passed away a few years back. He started a small company called Sunit Pharmaceuticals. छोटी company पर अच्छी company थी. Now Sunit Pharmaceutical, as you know, because name was Sunit Pharmaceutical, उनकी काफी product sun से चालू होती थी, like sun mycin, sun pie, something like. Now there is another big company, giant company called Sun Pharmaceutical, one of the largest company not only in India, in the world. उनका प्रोडक्ट भी सन से चालू होता था. One fine day, सन फार्मास्यूटिकल ने सुनित फार्मास्यूटिकल को नोटिस दिया कि आप हमारे ट्रेडमार्क जो है हमारा उसका वायलेशन कर रहे हैं. Why should we not take legal action against you? Dr. Dalal sir, a gentleman, was disturbed. He said कि दिलीप भाई संघवी, owner of Sun Pharmaceutical, मेरे को नोटिस दे दिया. He came to me and said कि पद्मी भाई देखो कैसा है, सन फार्मास्यूटिकल दलाल दिलीप भाई संघवी ने मेरे को नोटिस दे दिया. मैंने बोला दलाल साहब, दिलीप भाई संघवी को शायद मालूम भी नहीं होगा, उनका लीगल डिपार्टमेंट नोटिस दिया होगा, but let us check. We sat with a very prominent trademark attorney, discussed with him. We realized कि सुनित फार्मास्यूटिकल was on the back foot. सन फार्मास्यूटिकल ने काफी ट्रेडमार्क अपना रजिस्टर कर लिया था. सुनित फार्मास्यूटिकल को पता नहीं था. They started selling with the name of the Sun. So we advised Dr. Dalal कि आप ये don't go to litigation. Litigation बहुत costly है and you are on a weaker ground. You see, the point is, my dear friend, is that a learned person also having an industry also didn't know at that time about the importation of the legal rights, some kind of that. Okay. Then of course, बाद में दिलीप भाई संघवी को मालूम हुआ. He respect दलाल साहब. इसे कहने ने दलाल साहब ऐसा किया, कुछ तो करना चाहिए, तो उनको अलाउ किया था थोड़ा बहुत ट्रेडमार्क रखने का, but other trademarks they had to withdraw. Another case of a company called Ipca Pharmaceutical. उनका एक प्रोडक्ट है Zerodol SP, analgesic product. Okay. Another company, the name of Andros Pharma, came out with a product name called Zero Volt, similar category of product, and Ipca Pharma went to the Mumbai High Court and said, ये जो नाम रखा है दूसरी कंपनी ने वो हमारा जैसा ही है, structurally, phonetically, visually, and it is kind of the customer है उसमें कंफ्यूज हो जाएगा, ये नाम उसको अलाउ नहीं करना चाहिए. My dear friend, who does all these things? The legal people, the commercial people are involved when all this litigation takes place. Bombay High Court agreed with the Ipca Pharma and has ordered the Andros Pharma not to use word Zero Volt or Zero Volt or similar kind of thing. Okay. Why? Because it is confusing the mind of the customer. You of course know this very famous drug, Leaf 52 on jaundice by Himalaya Drug, a very nice company, research company. And just like Leaf Tea and many brands were came to the market, every time Himalaya Drugs and company keep on fighting, and they most of the time won. The message is, like, my dear friend, is that be aware of what to do and what not to do. Litigations are very costly and time consuming. If you are aware of the IPR norms, whether trademark, copyright or patent, you can avoid infringement, you can avoid litigation and create work. Okay. Somebody has again annotated it. Mr. Ajay, please remove this line. I request not to annotate while the presentation is going on. Okay. It disturbs everybody. Okay. Annotating is
Okay,
not
sir.
permitted, my dear friend. Please refrain from them. I can still see the red line on my slide. Okay, fine. Now this is very, it may look light, humorous, but the fact, Starbucks is one of the world famous brand in the coffee. A USA company, but world over. अभी गुजरात में अहमदाबाद में भी हमारे 4 Starbucks का outlet है. Now you see the copycats. Starbucks का copy, Starbung, Stardust and Starducks. ये जो Starducks है ना, उसका फोटोग्राफ मैंने लिया है चाइना में. चाइना में काफी ऐसा Stardust घूम रहे हैं, क्विक कर. Nobody bothers. So Starbucks keeps on fighting. Okay, the moment a product, a brand becomes famous, there are going to be copycats. That is the huge commercial importance of intellectual property right. Designs. Designs is an outer shape. Okay, it's an outer shape. Shape, configuration. For example, these are the machines. ये मशीन्स का जो शेप है उसका डिजाइन रजिस्टर करवा सकते हैं. फर्नीचर, ऑल द फर्नीचर्स आर रजिस्टर्ड द डिजाइंस. इसकी वजह से उसका परफॉर्मेंस अच्छा होता है ऐसा नहीं है. टैबलेट्स फॉर एग्जांपल, ऑल द टैबलेट्स आर रजिस्टर्ड डिफरेंट डिजाइन. कैल्शियम सेंडोज बहुत सालों पहले वाज द फर्स्ट कंपनी टू इंट्रोड्यूस डिफरेंट शेप्स ऑफ द टैबलेट, बिकॉज द चिल्ड्रन के लिए जो कैल्शियम टैबलेट था, द चिल्ड्रन वेर नॉट रेडी टू टेक. तो उनके लिए उन्होंने अलग अलग एनिमल शेप के टेबलेट बनाए हैं. So it attracted the children. They were ready to take the tablet because they liked the animal shape. So my dear friend, this is the importance of intellectual property right and various fields. Furniture is one of the biggest industry which basis on design. Jewelry, all the ladies and girls which they wear jewelry, all the important brands like Tanishq, the moment just before they launch a new design of jewelry in the market, it is registered under Design Act. So nobody can copy it. For example, this is a typical design infringement case, Troika Pharmaceutical, one of the most innovative company at the international level. Dr. Ketan Patel, again, alumna of LM College of Pharmacy. Again, an alumna of LM College of Pharmacy and my friend. Now, it came out with, he came out with a D-shaped tablet of his product, very famous product, Dynapar. Okay. And some other company came out with a similar D-shaped product, the same therapeutic category. Troika went to the court and Honorable Gujarat High Court agreed with the Troika. Okay, nobody should copy such kind of thing. Again, emphasizing the importance of intellectual to understand and know intellectual property right. Geographical indication, as I said, initially it was considered to be a kind of feeling of proud कि हमारे country या state से जुड़ा हुआ है. Now it has become a international marketing tool. GI is a sign used on goods having a special quality or characteristics or reputation based on the climatic or production characteristics unique to that geographical location. These are some of the examples. For example, Tirupati laddus. तिरुपति मंदिर में जो लड्डू सालों से बन रहा है, in terms of thousands and lakhs laddus as a prasadam, जैसे हमारा लड्डू है एक अलग तरीके से बनता है, उसका फ्लेवर, उसका टेस्ट, उसका शेप एक अलग आइडेंटिटी है. Now they have got a GI registration, so it is known as Tirupati laddus. Nobody can copy it. Gir Kesar mango, another product of Gujarat which has been given GI. Now Gir Kesar mango can utilize this GI name. It gives them authenticity and originality. Similarly, Darjeeling tea, Swiss watches, Indian carpets, and there are many more. Champagne is, my dear friend, is a drink made from grape and alcohol, but the champagne is the name of a place in France. सालों पहले फ्रांस में champagne ये ड्रिंक बनाया था because it was made in a place called Champagne. उसका नाम दिया गया champagne. As I just told you, Gujarat's Patana Patoda was been given GI. It has GI has a big factor in IPR. Dr. Narasimha Sahu, the head of GUJCOST, is working very actively. GUJCOST, which has sponsored this workshop also. I am also part of the GUJCOST. I am in this panel. GUJCOST is doing the tremendous work in promoting GI in Gujarat. Copyright, yes, the academicians are very much involved in copyright. It's a right given to creators of the literary, dramatic, musical works. All the work which are creative work, copyright is given. As I said, this is artistic work, musical work, entire film industry, entire entertainment industry, entire research, entire academics are under copyright. Let us take 1 minute to understand about, because we are in the academic field. Who owns the copyright? Academics normally give away their rights freely to publisher. आपने देखा होगा, any book which is published, there will be C. उसमें लिखा होगा all the rights with the publisher. प्रकाशक पासे बद्धा हक छे. प्रकाशक उसका जो पब्लिशर है उसके पास सभी राइट्स है. Why? ऐसा क्यों, my dear friend? उसमें क्या होता है कि सपोज मैंने कुछ बुक लिखा, रिसर्च पेपर लिखा, एक फिक्शन नोवेल लिखा, आई एम नॉट श्योर वेदर इट विल बी गेट पब्लिश और नॉट. अगर कोई पब्लिशर ऑफर करता है कि सर मैं आपका बुक पब्लिश करता हूं, then I will be happy. Then he will say कि सर मेरे को ये सब कॉपीराइट दे सकते, राइट दे दो, उसका जो सेल होगा उसका रॉयल्टी में सब मैं कर लूंगा. मैं बोला कोई बात नहीं, ये सब मेरे को इसमें नहीं पढ़ना है, मेरा तो बुक पब्लिश हो रहा है तो मेरे को अच्छा लग रहा है. But can we not have part of the right with us? उसका प्राइस, उसका सेलिंग, उसका रॉयल्टी, लेट द पब्लिशर डिसाइड. बट अगर कोई आपकी रिसर्च पेपर में से, आपका पीएचडी थीसिस में से या आपकी बुक में से कोई उसमें से पार्ट लेता है और यूज करता है, तो वो करना चाहिए कि नहीं करना चाहिए, वो राइट आपके पास होना चाहिए ना, जो ऑथर है उसके पास रहना चाहिए. इसको बोलते हैं कॉपीराइट ट्रांसफर एग्रीमेंट्स, जिसमें सम राइट्स कैन बी विद द ऑथर, अदर राइट्स कैन बी विद द यूनिवर्सिटीज और द पब्लिशर. Should academics seek to retain certain rights? Yes, we should. I work with a few universities, including one university in Delhi also, and they agreed, yes, ऐसा हो सकता है. Why not? So, my dear friend, this is the awareness we want to have. Copyright has emerged as a very important tool of IPR in recent years, mainly because of the film industry. Entire film industry is under the copyright, everything. And it's a big value industry. So copyright has become a very important component. Patent. We talk more about patent because it is direct impact on industry and economy. All the knowledge industries are affected by patent. Just make note, the India has both process patent and product patent. It's a very important, particularly for sectors like pharmaceuticals, chemicals, agrochemicals. If you talk about pharmaceuticals, because LMCP is involved, patenting in pharmaceutical covers all the entire range, whether it's a new pharmaceutical formulation, whether a new API, which is active pharmaceutical ingredient or bulk drug, a new drug intermediate, a new drug delivery system, or a new process, very important, to manufacture the same product, but like API. What can be patented? An invention which is new, an invention which is non-obvious. Non-obvious means वो चिराचर नहीं होना चाहिए, घिसा-पिटा नहीं होना चाहिए. An invention which is industrially applicable. That is the key. A patent cannot be granted if it is not proved कि ये सचमुच उसका उपयोग होने वाला है. जैसे मैंने बताया कि अगर किसी ने नया डिजाइन बनाया चेयर का, इसका डिजाइन बहुत अच्छा है, तो उसका डिजाइन मिलता है पर उसको पैटर्न नहीं मिलता है, क्योंकि उससे उसका परफॉर्मेंस अच्छा नहीं होता है। पर अगर कोई ऐसा चेयर बनाता है, उसका डिजाइन तो अच्छा है पर उसकी वजह से उसका बैकएक कम होता है, तो उसको पैटर्न मिल सकता है। तो इट इज इंडस्ट्रियली एप्लीकेबल। This is the typical process. I am not going in detail. My speakers after me are going to talk about how to file a patent, those kind of thing. Let me tell you one thing. Yes, as Dr. Chabaria said, you require to understand how to file patent or IPR, but it is not so cumbersome now. First thing. Second thing, a lot of facility and mentorship is available when you want to file a patent. So never ever hesitate that आपको पेटेंट कैसे फाइल करने का पता नहीं है. You get all the facilities. You can always welcome to approach me also. I will guide you all the way. When you file a patent, now this is the typical territorial system. अगर आप गुजरात में हैं तो आपको मुंबई में पेटेंट फाइल करना पड़ेगा. All the states in western region in Mumbai, all the states in southern region in Chennai. So this is essentially administrative setup. Everything is online. These are the patent fees applicable when you file a patent. Don't worry about this fees. Yes, fees तो भरना पड़ेगा, ये गवर्नमेंट ऑफ इंडिया का फीस है. But why I am saying you should not worry about the fees? Because in Gujarat particularly, you get 75% back when you file a patent. 75% तक आपको वापस मिलता है. There is also a scheme of student startup and innovation policy, which is part of this workshop also, which gives all the financial support for filing a patent to the academicians, students, everything. Okay, this is the support as I was saying. As per the new industrial policy, Government of Gujarat, 75% of the cost of expenditure is given back. That includes the international patents also. And now process patents also are eligible for finance. So financial, everyone, this is the SSIP, student startup and policy, which not only gives financial support, it also gives mentor assistance for filing a patent. So my dear friend, never hesitate. And now they are going to include GIE, trademark, design also. So never ever worry about financial part and the mentorship or guidance part of it. Okay, the ecosystem for helping IPR and patenting is a very solid, very comprehensive in the states like Gujarat. Patents are for 20 years, okay, from the date of filing. And to continue the patent for 20 years, one has to pay renewal fees every year. It has to be kept in mind. Similarly, trademarks also can be renewed every 10 years. Designs are only for 15 years. Okay. Geographical indications can be renewed forever, and copyrights are for 60 years. So these are the basic terms. There are certain do's and don'ts in terms of the tips. File the patent at the earliest, or file any IPR with a trademark, design at the earliest. Don't sit on it. There is an excellent scheme available called provisional patent. What is provisional patent? Somebody is working on some innovation. अभी इनोवेशन कंप्लीट प्रोसेस कंप्लीट नहीं हुआ है उसका, अभी रिसर्च चालू है, बट यू कैन फाइल अ प्रोविजनल पेटेंट. आपको 1 साल मिलेगा. सपोज यू फाइल अ प्रोविजनल पेटेंट ऑन 1 अक्टूबर 2021, तो आपको 1 अक्टूबर 2021 से 1 साल टाइम मिलेगा. उसके अंदर आपको बाकी का डिटेल आप फाइल कर सकते हैं. व्हाट इज द एडवांटेज? योर इनोवेशन स्टार्ट्स गेटिंग प्रोटेक्टेड. You also get a priority date. अगर आपके पास आपका जैसा ही कोई इनोवेशन करके पेटेंट फाइल करना चाहता है तो आपको पेटेंट आपको मिलेगा, उसको नहीं मिलेगा. You should also go for patent search. What is patent search? आप जो इनोवेशन कर रहे हैं, जिसके बाद आपका पेटेंट फाइल करना चाहते हैं, ऐसा दूसरे किसी ने तो पेटेंट फाइल नहीं किया है ना, या किसी को पेटेंट ग्रांट नहीं हुआ है ना वर्ल्ड ओवर, वो जानना जरूरी है. Don't disclose your patent related information before filing. ये काफी लोगों को पता नहीं, particularly academicians. I used to receive so many students and faculty कि सर मैं डेमोन्स्ट्रेशन करना चाहता हूँ, I want to publish a paper on my innovation. मैं इंटरव्यू देना चाहता हूँ, लोग मेरे को पूछ रहे हैं. I said wait for it. पहले फाइल कर दो पेटेंट. You can file a provisional patent also. Then announce to the world. No problem. क्योंकि नहीं तो दूसरे लोग जानते हैं आपको you will not be eligible for patent. And ये सब जानना जरूर इसलिए है कि you can avoid yourself from the litigation. Litigation से दूर रहना बहुत जरूरी है, particularly small scale industry and academicians. And these are the e-gateways of filing patent. Everything is online, my dear friend. It is a very, very easy process. If your basic details are ready. E-filing of the patent, e-filing of the trademark, e-filing of the designs, e-filing of the GI, copyright. And this is the website, www.ipiindia.nic.in. It's a very dynamic and friendly website of Indian Patent Office. This I want to make sure that you know, patent is territorial. उसका मतलब क्या है? अगर किसी ने पेटेंट इंडिया में फाइल किया है और यूएसए में फाइल नहीं किया है, तो आपका जो इनोवेशन है उसका उपयोग यूएसए में लोग कर सकते हैं. Similarly, if somebody has filed a patent in South Korea but not in India, you can manufacture and market the same technology, based product, the same technology, because that person or company has not filed the patent in the country. जो कंट्री में पेटेंट फाइल होता है और मिलता है उसी में वो प्रोटेक्ट होता है. ओके, ये बिजनेस डिसीजन, लाइक ट्रोइका फार्मास्यूटिकल फाइल्स पेटेंट इन 70 कंट्रीज, बट पहले जब 10 साल पहले इट यूज्ड टू फाइल इन 10 कंट्री ओनली. इट्स अ बिजनेस डिसीजन, बट दिस इज वेरी इंपॉर्टेंट टू नो. There is nothing like global patent. If somebody tells you it's a global patent, there is nothing like global patent. आपको हर एक कंट्री में अलग अलग से पेटेंट फाइल करना पड़ेगा. What are the importance for academia and business? Yes, earlier we told, Dr. Manish and other people also told, it's a knowledge economy. In knowledge economy, we do innovation, we do research. It has to be protected, and that is why IPR has become important, because world economy has shown the paradigm shift. It gives exclusive ownership, it adds value, it adds to the market image, and that leads to business tie-ups, including for academicians, let me tell you. And this is the way one can commercialize IP, whether it's a trademark, whether it is a design, whether it's copyright, or of course patent. You can license it, royalty based. You can straight away sell your patent. Patent can be sold and bought. You yourself can do it, utilize it, or there could be joint venture or collaboration. Dr. Purushottam, the former head of NRDC, is going to talk about IP commercialization. So I'm happy. Of course, now he's a chair at Andhra University. So he'll be talking about commercialization in detail. So let me conclude. Because there are several people in pharmaceuticals, in general also, 80% of the overall revenue of pharmaceutical is through patented products, my dear friend. And it has become very important now. Dr. Carlo also mentioned about the patent being given like vaccination. Now in vaccination, yes, India and other countries are telling if for at least some period patent should not be given. बाद में patent दे दो. But pharmaceutical industry is based on patenting. And there are so many ways one can go for IP opportunities in pharmaceuticals and related industries, process patents, niche innovations, substitutes, new drug delivery system, herbals. I will just take half a minute to talk about herbals. Look, herbal and traditional medicine is one of the biggest opportunity for a country like India. And you don't have to be a pharmacy graduate for that. You can be a commerce graduate and do excellent work in herbals. As such, traditional products knowledge cannot be patented. What can be done is to do some innovations further than that. China, countries like China and Brazil are doing excellent work. India also has an excellent biodiversity. We have got thousands of medicinal plants. we can do some good work on that and go for patenting, and there is a huge market for that. So concluding, there is a scope for academic, research and industry interface. World over, initial research takes place in academics, whether you go to California in USA, whether you go to Israel or South Korea. Academicians do the research work, they have the knowledge. Then industry is invited, industry comes, and they decide which of the work being done by academicians can be taken up for further development. The patenting or design and copyright can be joint ownership. There could be joint patents. Then it will be commercialized through industry because that is their world. Initial work by academician, commercialization by the industry. Again, whatever the financial rewards are get, that can be shared because everything is properly done by agreement. And that is why it is called from Saraswati to Lakshmi, the goddess of knowledge, which is with the academicians and research institutions, to the Lakshmi, the goddess of the wealth. This is so much required. I know that LM College Pharmacy and other institutions are working on it. GTU also working on it, but more work needs to be done for this academic industry collaboration. This Saraswati to Lakshmi, my dear friend, is not my word. This was coined by Dr. Maselkar, who is a doyen of the research in India and doyen of the IPR in India. So this is the significance of IPR. You create, you protect under IPR, you apply, and there is a successful business. Whether it is a patent, whether trademark, whether copyright or design or GI. And I'm again emphasizing, yes, pharmaceutical industry, patent and IPR are very important. But who is going to help them? The people having commerce background, the people having law background. So it is an integrated process, my dear friend. That is why I always say invest in innovation. Investing not only in money, investing the time, investing the knowledge, investing other resources. That is what the India is looking forward to. And for that, to create a business and knowledgeable society, our Honorable Prime Minister's quote is a very relevant quote. Mind is not a problem. We all have mind. We know ऐसा करना है, पर करते नहीं है. You have to change the mindset. We have to change the mindset. A number of my friends are running their industry, small and medium industry, the engineering or ceramic or textile or pharmaceutical. I always tell them, hey, look, we are doing well, but why don't you go for some innovation? और अगर कोई दूसरा कोई यूनिवर्सिटी इनोवेशन करती है, कॉलेज इनोवेशन करते हैं, तो आप इनोवेशन को देखो, चेक करो, उसमें आपको काफी फायदा होने वाला है. वो इनोवेशन आप अपने पास ले लो. So that is a changing of the mindset, and those companies who are doing that, they are ahead. They are proactive companies. Okay, I will stop here. Thank you so much for giving me opportunity. If I have taken a little bit more time, I pardon me for the same. Okay. If there are any questions now or in future, I'll be happy to answer those questions.
Thank you so much, sir, for giving such a wonderful overview of IPR and also
Disturbance from your side, madam.
Hello, am I audible now?
You are audible, but there is some static noise.
Oh, okay. Thank you so much, sir, for giving such a wonderful overview of IPR and also giving live examples of trademark, copyrights, geographical indication, and many more IP. The session is open for question and answer. So if you have any questions, please write in the chat box.
Yeah, if you can speak out the question, it will be easier for me. Or maybe I will see the chat.
Isha, there are some questions.
Yes, sir. We have few questions. Like,
Can somebody speak out the question for me? It will help me.
Yes, sir. Yes, sir. Yes, sir. Sir, the question is that, sir, every product and invention is patentable. The Poonam Kunwar asked the question. Sir, every product and invention is patentable.
Not really. It's a good question. Look, if you talk about law, under the section 3, A, B, C, and D of Indian Patent Act, there is a list given where it is said that these are the categories of the product and innovation which cannot be patented. Okay. So that, for example, traditional medicines cannot be patented in a raw form. हल्दी कैनॉट बी पेटेंटेड, पर आप हल्दी में से काम करके उसका स्ट्रक्चर चेंज करके आप करेंगे फाइल तो उसका पेटेंट मिल सकता है. Merely mixing of two products cannot be patented. So जो definition है, it should be new, it should be non-obvious and industry applicable. That is the basic fundamental to decide whether everything. There are certain innovations which are not socially acceptable. Like किसी ने कैसीनो मशीन बनाया अच्छा, तो उसका पेटेंट नहीं मिलेगा. कैसीनो मशीन कितना भी अच्छा है उसको बोलना पड़ेगा कि आप हांगकांग चले जाओ उपयोग करो, इंडिया में उसका पेटेंट नहीं मिलेगा. So every innovation is not patentable, but there are a lot of scope for patenting also. So one has to discuss with mentors, knowledgeable people who are available. उसके बात करके आ जा सकते हैं to understand कि ये patent मिलेगा कि नहीं मिलेगा. Dr. Rajesh Acharya is already here. I can see him. You can meet him. You can meet other mentors. You can come to me. Understand आप कुछ innovation कर रहे हैं कि ये patentable है कि नहीं है. Then you can go further. Okay. Yeah. Any other question,
Sir,
please?
yes, sir. So one more question is there in chat box. As you said, Tirupati got GI registration. So is even GI required to register?
Sorry.
Geographical.
Geographical indication.
As you
Okay.
said,
Okay. Now geographical indication is a very different kind of setup. If you can say you feel it is just like a trademark, but it is not a trademark really. Trademark is given to a product or a company. Geographical indication is given to a group of people, either group of farmers, group of the artisans, like Darjeeling tea. All the people in the region of Darjeeling who are either cultivating or processing tea, which is a specific flavor, aroma, look, they are given as a common mark as a geographic indication. It is unlike trademark, which is given to a particular product. Second thing, trademark is not associated with the feature of that particular region. GI is associated with it. But GI has a great value if somebody comes across a product, whether either being cultivated or produced in a particular state or a region since many years, it is something very different. One can apply for geographical indication and one can get geographical indication. Like Patan का पटोला का ऐसा ही चीज था, इतने सालों से बन रहा था, that it was decided कि it is something very distinct and वो पाटन में ही हो सकता है, तो उसको GI दिया गया है. तिरुपति जो लड्डू है या तो दार्जिलिंग टी है, यार basically तिरुपति लड्डू is more of a kind of feeling of being pride कि ये हमारा कुछ अलग तरीका है. But let me tell you, all the people, particularly who are not necessarily technical, who are the field of commercial legal people, I would suggest that if you are working with some kind of NGOs or such kind of people, you can identify such kind of product and go for GI. GI has emerged as a very, very important intellectual property right component. And GUJCOST will help you. GUJCOST is working actively. Dr. Narottam Sahu and his team is working actively to promote geographic indication. Government of India has practically waived off all the fees. अगर आपको GI फाइल करना है तो you don't have to pay any fee. So Government of India is also encouraging GI because it is realized that it is good for the country, state, and it gives an identity to the country and the state.
Sir, we have one more question is there. Our software are patentable?
What?
Software are patentable.
Software. Okay. Okay. Now important. I am happy that this question is asked. In fact, I have mentioned in the slide, but I did not elaborate. Software as such in India are not given patent. if you develop a software, maybe you will get a patent in USA, but not in India. In India, software can be protected under copyright. The Government of India law framework says it is a creative kind of work, a creative kind of domain. So it has been covered under copyright. So a software developer, a new software is not patented in India, which people like me, maybe Rajesh Bhai also, or other people may agree. We believe that software should be patented in India also. In fact, for a few years, I was in a committee group of Computer Society of India. We had several meetings at Delhi also, and we tried to convince the Government of India authorities कि भी आप software को patent करवा दो. But the government was not convinced. आज की तारीख में software can be protected under copyright. So you can get a protection. So that you can assure of. You can protect your software under copyright and prevent other people from copying your software which you have developed as a new. But otherwise, software is not patentable in India. We hope in future it will be included in the patenting also. Okay, does it answer your question? I hope so.
Because of time constraint, we will now end the
Madam, I am not able to hear. A lot of disturbance.
Because of time constraint, we will now end the Q&A session. We have our next session scheduled at 11:45. Now I would request Dr. Mahesh Chabaria sir to present e-certificate to Dr. Padmin Buddh sir.
Oh, that is so nice. Thank you so much, Dr. Chabaria sir. And
thank you, Padmin Bhai. And please accept our token of gratitude.
Yeah, yes. It carries a great value. Let me tell you. It carries a great value for me. A certificate is a resource person, that too from my own college and all the other institutions. Thank you so much.
Thank you.
Once again for inviting me. And I always am available whenever anybody wants to approach me. Of course, I am part of the LM College of Pharmacy. Their education cell also. I am on the panel also. So
nice.
Thank you so much once again.
Thank you very much. Thank you.
Okay. So may I leave now, sir?
Yes, sir. Thank you very much.
Okay. Thank you all. All the best for the remaining part of the webinar.
Thank you, sir.
Rajesh Bhai, sorry if I have encroached into your domain. Okay, sir. So Rajesh Bhai, may I leave? Dr. Rajesh Bhai,
Thank you so much, sir.
Okay, fine. Okay, I'm leaving now.
Really wonderful.
Thank you so much. I have to have some other commitments, so I will not be able to leave.
I can understand. Right.
Thank you so much.
Our next speaker for the topic Indian and International Patent System is Dr. Rajesh Kumar Acharya. Dr. Rajesh Kumar Acharya is a proprietor of HK Acharya and Company, is a patent and trademarks attorney who is multitasking in creativity and commitment to the intellectual property matters. He provides comprehensive action plans to national and international clients in a wide range of fields to protect their immensely valuable intangible assets. Under his guidance, the firm has grown from a modest beginning to its present position as one of the leading intellectual property firms in India. He has accumulated a wealth of experience in prosecution and litigation of patents, trademarks, designs, copyrights, and other intellectual property related matters. He is registered to practice before Canada Patent and Trademark Office. His research papers published in various national and international journals and magazines on intellectual property rights become guide for associates and clients in planning the future. He is a member of various national and international organizations related to intellectual property laws. He is also a member of Indo-American Chamber of Commerce and the president of US chapter of United States India Importers Council. I shall request to sir to begin with his talk. Thank you. Over to you, sir.
As it is still 11:46, I would like to say all of you good morning. Good morning, friends. As such, I am a little nervous because it was very entertaining general IP session by Padmin Bhai Buch. In intellectual properties, particularly trademark, patent, copyright, industrial design, and GI, patent is a very serious subject matter. And as mentioned by Padmin Bhai, that filing of the patent nowadays is very easy. To do the prior art search is also very easy. We can file the patent electronically. So nowadays, no need to go to Mumbai or any place. I remember that when I started working with the patent, I was used to go to Nagpur. It is a IPO office for references. But nowadays, we can do the prior art search on the computer. We need not go to Nagpur and any place, but we can do the prior art search from our office. We can file the patent from our office. So we are rather a part of the Indian Patent Office in our office. It is working 24 hours. We can file the patent, we can do the prior art search. Becomes very easy. But don't think that patent drafting is easy. Patent drafting is rather a very difficult thing. It is a techno-legal document which we'll have to prepare. And as far as the subject, Indian and international patent system, Padmin Bhai has mentioned many things in his presentation. I would like to tell you that it is a territorial patent. So if we file the patent in Indian Patent Office, it is having limitation of production in India only. So then question arises how to file in other countries. So there are two ways of filing the patents in other countries. One, it is within 12 months, we'll have to file our patent in other country, and we can get the date of priority of filing in India in other countries. Second is a PCT route. It is Patent Common Treaty, where about more than 140 countries are there. And if we file a PCT application, we get a 30-month to file in other countries after filing in India. And we get a protection from the date of filing in India. And within 30 months, we can find the potentiality of our invention. So we can decide whether to file in which country and whether to file or not in other countries. So this is some basic information about filing the patent at national level and international level. I'll say that patent can be filed by either by the patent agent or his client or by the applicant itself. Filing the patent, and suppose if you get the patent also from the patent office, but if it is not properly drafted, then it is of no use. And in the court, you may lose it. Because when you are filing the patent, before that, you have invested a lot of money, a lot of time, a lot of energy. So I'll say that very clearly and politely say that if you don't have the experience of drafting the patent, take the help of patent attorney. Because drafting of the patent, it requires very high level of the skill as well as knowledge of the patent. Now I'll go for my slides one by one. I like to say that patent is a little bit boring subject because now, before going to the little bit academic things about the patent, I would like to tell you that why I started with the pharmaceuticals patent. Because I know that this is an appreciation and where it is organized by Tolani Commerce College in collaboration with LM College of Pharmacy. Long time ago, first patent of the LM College of Pharmacy was drafted by me and filed by me. And nowadays, today, I am making a presentation for pharmaceutical, much more on the pharmaceutical patent. But before that, I would like to add something. There was one question that whether software can be patented or not. I'll add to what Padmin Bhai said. Software per se is not patentable, but if software is bundled with hardware, if hardware runs by the software, then both as a bundle can be patentable. This I would like to add. Now, in the patent, there are two ingredients of the patent. One is the clear title of your invention. Then you should go for prior art search. That should be the part of your patent drafting. It is known as a part of the patent when you draft the patent. Third is working of the patent. Fourth is claims. Also, you have to make an abstract of your invention that also you are required to submit. And most critical thing in the patent is the claims. So when you draft the claims, it requires very high skill, the technicalities, and also patent law. So what is claim? It defines boundaries of the legal protection sought by the patent, which is a most important part. Claim defines boundaries of the legal protection. As I mentioned, any matter which is a part of specification but not a part of claims, then it is considered as disclaimed. So whatever you think that this is a very important part and you have done the invention which is matching nowhere, then you must put it in the claim. If you do not put in the claim, then whatever the long patent you adopted, it will be useless. Now, what to be considered while drafting the patent claims? It should be single sentence and clearly worded. Example, Grisha, it is, I'll say that a composition comprises plants of family Lauraceae. Not clear as it is claiming composition and only one ingredient is mentioned. Further, it is too wide as Lauraceae include more than 4,000 species. Then it is precise and without unnecessary repetition. There should not be repetition. Example, a composition as claimed in claim 1, wherein compound X is like salt. Not precise as word like is not showing exact property of compound X. Third, rights are given to claims only. Don't forget that rights are given to claims only. Claims define the boundaries of legal protection. Example, a composition comprising of 10 to 20% X and 80 to 90% Y. So in this case, 1 to 9% and 21 to 100% range of X is disclaimed. Again, where in a composition you are mentioning that a composition comprising of 10 to 20% X and 80 to 90% Y, then in that case you are disclaiming 1 to 9% and 21 to 100%. And figure out all the essential features of elements of invention. Also, start claims on a new page and number each claim I/V claim. When it is an application made by single applicant, then it should be I claim. And if the more than one applicants are there, then it should be V claim. Then when you start drafting the claim, then start with broadest claim. The first claim must be independent claim and subsequent claim may be dependent claims. There is no restriction to the number of claims. You can have n number of the claims in your invention. Whatever you find new in your invention, you can put it as a claim. However, if claims are more than 10 numbers, then additional fee has to be paid. But fees are not very high. Your claims are very, very important. And all claims must be supported by the description and based on the description in your patent drafting. If your claims doesn't describe anywhere in drafting of your patent, then it is useless. It will not be given any right. Now, neither more not less than desires. Moreover, scope of claims must not be too extensive. Must not be too extensive, not expensive, but it must not be too extensive. It must not be too narrow. I like to say more about must not be too extensive means a composition for the treatment of fibrosis comprises 1 to 100% X and 1 to 100% Y. It is too extensive. but don't make it too narrow also. Like a composition for the treatment of fibrosis comprises 65% of X and 30% of Y. Don't make it, it becomes too narrow. Many claims where each one has a different scope allows to have legal title to several aspects of the invention. Now, what are the basic structure of claims? Now, basic structure of claims, it is preamble or introductory phase of prior art, main body of the claim or inventive part of the claim, and the linking word that joins the two. When there are more claims, then there should be one linking word that joins the two. What are the linking words? First of all, let us talk about the preamble. A formulation for promoting weight and fat loss in an individual in need thereof. Linking is comprising. Main body. Co-abbreviation to say individual daily effective weight and fat loss promoting amounts of L-carnitine, chromium picolinate, creatine, alpha-lipoic acid, niacin, pyruvate, riboflavin, thiamine, and coenzyme Q10. These are the main body. Now let us see about linking part. First is comprising. It comprises or comprising. It gives protection beyond the elements mentioned in a claim. Including, it does not give protection beyond the elements mentioned in a claim. Consisting of, it is a restricted phrase, then other, including, it is used when other elements are considered at the time of interpretation. It may give drastic variation in result. Consisting essentiality of, it is less restricted phrase. It may allow potential changes that are not essential. And when you put varying, it is used to define further boundaries of claim. Now, what are the type of claims? First, it is independent claim or principal claim. When you start drafting the claims, it should start with an independent claim or principal claim. Essential novel features of the process. It should be the essential novel process of the process, apparatus, device, or the product that constitute the invention. It should be independent and principal claim. Others are dependent claims. Clubbed with dependent claims are clubbed with the independent claim to include all features of the independent claim. In one independent claim, there may be number of dependent claims. Then after dependent claim of the first independent claim, there is one more independent claim and further dependent claims on second independent claim. It may be. Then in the patent system, there is also omnibus claim. Omnibus claim, it is rather a very old fashion in other countries where omnibus claim was considered to be the part of the claims. So when you cannot extract out the claim in your claim session, then you could write to get an integral protection of what is described in the specification drawing. It was there, still it is in other countries, but in India, in Manual of Patent Office Practice and Procedure, it is mentioned that the practice of including an omnibus claim does not have any legal basis under the Patent Act. In Patent Act doesn't mention, it is not mentioned anywhere in the Patent Act about the omnibus claim, and therefore does not have any legal basis under the Patent Act. In fact, such a claim cannot be allowed as per the section 10(4)(c) of the Act. As such, claims are unclear, vague, and unsearchable. It is desirable to avoid omnibus claims in a patent application. So now in India, omnibus claim is not allowed. But if you want to file your patent application in other countries also, then you may put omnibus claim as the last claim. Because when you file a PCT application, you file the patent as it is in other countries. So maybe in some other countries of your choice, omnibus claim may be allowed. Don't worry of India at this time by putting omnibus claim. We are sure that Indian Patent Office will not allow that claim only. It will not disallow your other claim, but it will disallow only your omnibus claim. Let Indian Patent Office disallow omnibus claim, but you can use that omnibus claim in other countries. Now, there are Marcus type claim. Chemical structure by means of symbols indicating substitute groups. With chemical structures, it is often possible to use many substitutes in a given structure. The method of claim 1, wherein R1 of formula V comprises a cation selected from the group consisting of tetramethyl ammonium, tetraethyl ammonium, tetrabutyl ammonium, tetraethyl ammonium, diisopropyl ethyl ammonium, N-methyl morpholithium, and pyridinium. These are some of the Marcus type of claim. Now, there is a unity of claims. In unity of claims, if one has invented a new kind of roll-on bottle, the invention can be claimed in the same application for 1, the roll-on bottle itself, it is a product. B, method of making the roll-on bottle, it is a process. Apparatus used for making the said roll-on bottle. So these are the unity of claim for a new kind of roll-on bottle, where you can claim the bottle, you can claim method of making the roll-on bottle, and also the apparatus used for making the said roll-on bottle. Now, I'd like to tell you something about genetically modified gene sequences or amino acid sequences. This is nowadays very, very important and red hot area. Patent can be obtained for gene sequences or amino acid sequences. A method of expressing above sequences. An antibody against that protein or sequence. A kit made from the antibody or sequence. So who are working in genetic area, you please write down these, that genetically modified gene sequences and amino acid sequences are patentable. Now, about drug or pharmaceutical product. Drug or pharmaceutical product patent can be obtained for a drug or pharmaceutical product. Second, modified drug or pharmaceutical of a known compound is proved to be more efficacious than the known compound. Again, modified drug or pharmaceutical of a known compound is proved to be more efficacious than the known compound, it is patentable. a process of making the product as defined in A or B, and a formulation containing the drug A or B. It is patented. Now about herbal, chemical, or pharmaceutical, or a medicinal composition. We know that particularly in these nowadays in pandemic situation, many herbal medicines came out and allopathic medicines came out. So a product by itself, if it is novel, then a process of extraction and or process of mixing the ingredients either pre-prepared or extracted are patentable, or apparatus, if novel, either for the process of extraction and or for the process of preparation are patentable. These are very, very important for herbal Ayurvedic medicines also. So don't think that Ayurvedic or herbal patent invention are not patentable. It is patentable. And let us use a different type of pharmaceutical claim. One, it is chemical compounds. You can put it chemical compound with novel in your patent. Then first medical use of novel compound, if it is invented, then it is patented. Second medical use of known compounds, in some of the countries it is not allowed, but in some of the countries it is allowed. There is also a Swiss type claims. There are also method claims and product by process claim. We'll talk about this in detail in our next slide. Now, what are chemical compounds? A compound having the formula RCH double bond and SSX, wherein R is an alkyl group selected from the group consisting of methyl, ethyl, and isopropyl, and X is a halogen selected from the group consisting of chlorine and bromine. This is a chemical compound which may be patentable. While first medical use of novel or inventive compound. Now, you mentioned in first claim the chemical compound, which is novel, which is patentable. Now, it is first medical use. A chemical compound of chemical formula, RCHNSX, used as a medicine to treat skin burns. So in the first claim, you claim chemical compounds. Now you are claiming first use, which is also patentable. Now, second medical use. In some of the countries, second medical use is not allowed. After filing the application, if person finds that the chemical compound RNS are used also against a chemical compound, a chemical formula used as a medicine. But after filing an application, if you come to, then you can add this claim in your application. Now, very important is a Swiss patent. Use of chemical compound of chemical formula RCHNX for producing therapeutic agent for treating skin burn. Swiss type means it is current European Patent Office. This is one of Swiss style claim. Now comes the method. A method for preparation of compound having the formula RCHNX comprising step of taking substance A and heating at 60 degrees centigrade, adding substance B. This method of preparation of compound having the formula, it is this type of claim of method, it is also patentable. Now, it is product by process. If product A is obtained by process B, and also patentable. Now, let us talk something about herbal thing. Now, if somebody has made a herbal face cream, now a composition for herbal face cream, the present invention provides a composition for herbal face cream suitable for oily skin, which comprises yogurt, this much to this much milligram, turmeric, this is curcuma longa, extract is 6 to 10 ml, lemon juice, it is 8 to 16 ml, orange, always mention the pharmaceutical, botanical scientific name also. Orange, it is Citrus reticulata, extract 15 to 20%, carrot, it is Daucus corolla, extract 15 to 20%, natural oils selected from olive oil, linolenic, landering, and fatty acids for then this is the composition of herbal face cream. Now, how will put into our claims? And in this invention, we mentioned we are preparing the claim, a composition for herbal face cream suitable for oily skin, which comprises yogurt, this much 6.5 to 7.5 milligram, turmeric, curcuma longa, extract 6 to 10 ml, lemon, Citrus medica or acida juice 8 to 16 ml, orange, Citrus reticulata, extract 15 to 20 ml, carrot, extract 15 to 20 ml, and natural oils quantity sufficient. This is our claim 1. Now, in the second claim, this is our principal claim. Now, second claim, the composition is claimed in claim 1, wherein now we are becoming more specific, wherein the natural oils is selected from olive oil, linolenic, or mixture thereof. So, it is a dependent claim. Now, third is a process for preparation of comprising the steps of how we'll take the yogurt and mixing lemon juice. How will you do it? It is all the process for preparation. It is a process claim. A composition for herbal face cream suitable for oily skin, substantially as herein described with reference to the acceptance. This is all not a real one. It is exemplary how to draft the patent for such things. Now, in the next slide, it is a process for recovery for hydrocarbons from oily sludge. Now, homogenizing sludge by agitation with kerosene water mixture in a ratio ranging X to Y at a temperature ranging between this to this, growing culture of Methanococcus chamnosity ATCC 2311 in about 5% maltose as carbon source for about 10 hours to obtain fermented, both containing acetone acting as de-emulsifying agent to provide de-emulsified sludge, separating hydrocarbons from de-emulsified sludge by centrifugation. So this is the invention. Now, what will be the claims for this? Claims will be a process for recovery of hydrocarbons from oily sludge comprises, what it comprises? Homogenizing oily sludge by treating the said oil sludge with kerosene water mixture in a ratio ranging X is to Y at a temperature ranging between 20 to 35 Celsius. B. Growing culture of Methanococcus tenaci 862311 in about 5% maltose as carbon source for about 10 to 15 hours to obtain fermented broth containing acid. Now, treating the homogenized sludge obtained from step A above with fermented broth containing acidion obtained in step B. Now, second claim, it will be a process as claimed in claim 1, step B, wherein more preferably treatment fermentation period is 13 hours. These are part of the claims. Now, let us see next. Now, XYZ compound analysis. The invention relates to compound of formula 1, where the formula is shown. The compounds, according to the present invention, are useful in numerous diseases, disorders, and conditions. In particular, allergic and respiratory diseases, disorder, and conditions. Now, where R1 is alkyl, substituted alkyl, aryl, substituted aryl, aryl alkyl, substituted aryl alkyl, cycloalkyl, substituted cycloalkyl, heteroalkyl, substituted heteroalkyl, and like that, or substituted aryl. And where R2 and R3 are independently hydrogen alkyl, substituted alkyl, alkoxy carbonyl, substituted alkoxy carbonyl, aryl, substituted aryl, everything should be covered. And R2 and R3 together with the atom which they are bonded form a cycloalkyl, substituted cycloalkyl, cycloheteroalkyl, or substituted heteroalkyl ring. Now, what will be these are your invention, what will be the claims? This is the claims where compound of formula 1, where you are not clearing what is R2, R3, R1, anything, but you are putting it general, and where you become more specific by mentioning wherein. Wherein means in the above structure, chemical formula. Where R1 you are mentioning what is R1 you are invented. So R1 is this alkyl, substitute alkyl, aryl, some whatever you want to take and whatever you've done in your invention, you can put it. Also R2 and R3 also you can be mention about whatever you've done in your invention, and you can mention all the things over here. And so all these compounds in that formula will be part of the claims and it will be protected. Now, second claim. The compound is claimed in claim 1, wherein optionally R2 and R3 together with the atom to which they are bonded form a cycloalkyl, substituted cycloalkyl, cycloheteroalkyl, or substituted cycloalkyl. And a compound of formula 1 and salts. You can see the formula 1 and salts and solvents thereof, wherein R1 is isopropyl, R2 is isopropyl, R3 is hydrogen. So these are how we can draft the patents. Now, I will go for Y.X. So it mentioned in which country the chemical entity, first use, second use, which type, and new methods are patentable. Sorry for this video. You can now see the video. I think all of you can see that. Or patent application received per office in 2009, 2010, 2011, 2012, 13, 14, 16, 17, 18, 19. Actually, WIPO is having the figure until 2019. I would like to tell you that patent filed in USA was top in the past. Second was the Japan. Maybe third was China and other European country. Nowadays, US is filing about 4 lakhs patent. Japan is filing 3.5 lakhs patent every year. Last 2020 also, it is around 4.5 lakhs in USA, about 3.5 lakhs in Japan. And you know that our sweet neighbor, China, in 2019, they filed about 2 million, that is 20 lakhs patent in a year. In this pandemic, even though China was the most affected, they filed 3 million patent applications. No doubt, Chinese government promotes the patent filing by all the means. And the sad picture is of our India. We are filing about 45 to 50,000 patent applications in a year. Out of 40 to 50,000 patent applications, 60 to 70% are foreign-based. So in last year, I think 17,000 patent applications filed from Indian people. What is the reason? We have to analyze it. When we are in USA, our engineers are doing wonderful job filing and creating a lot of software. They are part of many patent applications. India, maybe we are having a socialistic culture. Bahujan Sikhai. We should not have the monopoly of the knowledge. But when we have to compete with the world, we should file more and more patent application. So whatever the money, time we have invested in our invention, we must protect it. With this background, I'll go on the next slide. Now the comparison of Indian pharma patentability with other countries. Category of invention. JPO for chemical entity, yes. EPO, yes. Every country is giving a positive for chemical entity. First use, that is allowed in JPO, EPO, USPTO, but IPO, no. Second use, in JPO it is yes, EPO it is no, USPTO no, India also no. Second use is not allowed. Swiss type, no need in JPO, EPO yes, USPTO no need, IPO is also no. IPO means Indian Patent Office. New method, that is yes for all the JPO, EPO, USPTO, and IPO. Now, I'll say weightless economy. Here is slide. This is an animation series of DuckTales. of Walt Disney. It was by Mr. Scrooge, Money Swim. Friends, next slide. I think you like it very much because I would not like to be much more in between you and lunch. And this was a very, very heavy topic. So next slide. It is. Thank you. Thank you very much.
The session is now open for questions and answer. If you have any questions, please write in the chat box.
Good afternoon, sir. Hello.
Yes.
Yes, sir. Sir, there are a few questions in the chat box. One question from the participant is that I wrote some poems and other literature. So to prevent from stealing this document, where should I apply?
When it is a poem, you must apply for the copyright. And first of all, I'd like to tell you that before applying for the copyright, put in a sealed envelope and seal it properly and make it a self-address and send it to your own address. Don't open the seal and put it into safe deposit. And second, immediately, because by that you can say that you are a prior, you generated this and it is not a copied by anyone, it is your own creation. And second, you can apply for the copyright into copyright office. It is very, very easy and very fast also.
Okay, sir, thank you. One more question is there. If any invention, if any innovation is developed by any robot or artificial intelligence, so who will be the owner? If any innovation is developed by any robot or artificial intelligence, who will be the owner?
Actually, it is nowadays very, very debated question everywhere. But nowadays, according to this situation, patent can be owned by individual, that is a living person only. Only person can apply for the patent, and so robot is not a living person, so it cannot apply. And moreover, robot and all logic, all software, it is put by human being. So maybe the human being only can be the owner of that patent.
Sir, one more question is there. Is patent for the second medical use allowed in the India?
I mentioned that a second, even first medical use is also not allowed after you file the patent. So second medical use is not allowed at all in India at present.
One more question is there, sir. We would like to know more for IPR, for the research and arts and humanities. IPR for research in arts and humanities.
Will you please repeat the question?
Can you say something about the IPR for the research in arts and humanities?
If it is, you know that IPR is having 4 parts: trademark, copyright, industrial design, and patents. So when such institute, where it falls, or their invention or the intellectual property where it falls, whether it is a trademark of that institute, then we can apply for the trademark. If it is logo of that institute, we can apply for trademark as well as for the copyright. If it is some art, then it can go for copyright. And if it is industrial applicable, then we can apply for industrial design also. And if there is some invention which is novel, industrial application, then we can apply for the patent. So it depends in which folder it will fall.
Thank you so much, sir, for such an informative session on basics of patents, its parts, working of patents, Sir has also mentioned the importance of patent claims and detail regarding how the patent claims should be drafted. Thank you so much, sir. As a token of our love and gratitude, I would like to request Dr. Manish Pandya, sir, to present a certificate to Dr. Rajesh Kumar Acharya, sir.
Wonderful. This is an invention rather from your institute. Really wonderful, wonderful. Thank you very much. Thank you for having me with this wonderful audience. Thank you.
Sir, as a token of love and gratitude, please accept this on our
So I'm very happy on that. Thank you. Thank you, sir. Thank you very much.
Yes, sir. Thank you for accepting our invitation, sir. And your lecture is really very fruitful. And I hope all the participants may have get a good idea for whatever you have said, sir. So thank you very much again for joining. Thank you, sir.
Thank you. Thank you very much. And if anybody is having any question, they can shoot me the email and I'll certainly give the answer, because patent, I like the patent things very much, always. Thank you.
Yes, sir. Thank you. Thank you, sir.
Thank you so much, sir.
Thank you.
Now we'll take a break from our webinar to have lunch. I request all the attendees to return by 1:55 p.m. and rejoin the session using the same link. Thank you.